going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Good to see you guys. Second live tonight. Hope you guys are still doing awesome. Had a fun sob sit one earlier, and now we get on to tonight's regular schedule program. You guys are awesome. Before I hit that play button, we got Chris Barton. Chris Barton's a new member. Chris Barton, you've been around for a while. Thank you so much for becoming a new member. I'm gonna go ahead and guess that you had a gifted membership that ended, so you just became a member. I'm gonna guess because you've been around for a while. Thank you so much, Chris Barton. I appreciate the new membership. All right, before I hit that play button, you know what to do. Hit the like and subscribe to your junkie backflips. Let's go.
1 second here. Thank you. This is 240490. The People versus Stephen Haynes.
Good morning, Your Honor. James Gazicki on behalf of Mr. Stephen Haynes. Your Honor, Mr. Stephen Haynes is going to enter a plea of guilty to the charge of domestic violence, requesting that it be taken under 769.4A. There's no contact, substance abuse evaluation and treatment as directed, and it's 1 year, Your Honor.
And sir, you understand that because it's an assaultive case, you would not be subject to early termination. You would complete that 1 year of probation.
Yes, Your Honor.
And your attorney explained to you the benefits of taking that under the 7694A statute?
Yes, Your Honor.
All right. All right. And you understand that domestic violence, do we have a complainant on this one? Okay, yeah, we do. You understand that domestic violence is a misdemeanor in the state of Michigan. It's punishable by up to 90 days, or I'm sorry, 93 days in jail and a fine of up to $500.
Yes, Your Honor.
Okay.
All right, this isn't a bad time to pause it already. We're going to go through the boring court stuff before this one gets interesting anyways. Biggin, thank you so much for the raid. Thank you. We pulled some Inception. I rated you, then you rated me right back. That I didn't schedule it that way, but it works out. So Biggin, thank you so much for you guys all just came from there. I don't need to drop your link, but if my mods can please drop Biggin's link, that'd be amazing. Thank you so much, Biggin.
And did you go over your constitutional rights with your attorney?
Yes, Your Honor.
All right, I'm checking to make sure I have a advice or rights form in here because I don't see one.
Should be one in there. One was filled out.
I'm sorry, Mr. Gazicki, I see it. Did you go over your constitutional rights outlined on this advice or rights form with your attorney?
Yes, Your Honor.
And you understand, sir, that you'll be waiving those trial rights if you enter into this plea agreement. There will be no trial of any kind.
God, is there anything I can say?
Have you discussed it with your attorney?
Yes.
Okay.
I'm not guilty, but I can't afford to sit in jail. I have a life. I have a job. I need to get out back to my life. I've been here for 2 weeks, and I can't afford this. It's just a tough situation. I've been here for 2 weeks. I just want to get out and just get on with my life, but I don't want to go to trial and I have to still sit in trial and wait till the time to start the trial.
All right. For everyone who just joined, this guy is pleading guilty to something. And then the first thing that he says is, I'm not guilty. I didn't do this. I don't want to sit in jail. And Judge Shackleford politely said, did you talk to your attorney about this? And he said yes. all right. Yeah, don't do this. Do not do this. There's almost no judge that's going to take this plea. Are you pleading guilty? Can I say something? Okay. I didn't do this. I'm just doing this to get out of jail. Yeah, okay. Not taking it. Plea rejected. We're going to trial. Every single time.
I'm missing out on my life. I have job.
I can't take a plea if you're not guilty, sir. So, I
But-
mean,
But like, if I got to plead guilty to get out of jail to continue my life, I don't want to sit in jail no more.
I can't take a plea on that basis. Miss
Well,
David, refresh my memory on this case. Are there 1 second?
Sorry, ma'am. Sorry.
Aren't there 2 cases?
There was a case, Jessica Davidoff for the People P 8743. There are cases in the past as well where, the parties didn't end up going forward. But again,
In
let's
this
hear from
case,
you.
though, what isn't the reason that he's in jail right now? Because I wouldn't generally put someone in jail on a domestic violence, but I'm trying to refresh my memory. And isn't it that this case was pending? He had a no contact order with the complaining witness, and he is alleged to have been arrested on her front porch, intoxicated.
It could be, Your Honor. I don't have my notes in front of me. I can grab my computer to confirm that.
Ms. Weir, does that sound accurate to you?
Yes, it sounds very accurate. Yes, ma'am.
All right, so he was, Miss Davidoff, I remember this because I had an arraignment the other day on this. So the reason Mr. Haynes was in custody originally, Mr. Haynes had a $1,000 personal bond, and the conditions of the bond were that he has no contact with Miss Weir. So he was on bond, a very reasonable bond, and he is alleged to have been arrested. And I arraigned him at that point and reset bond because he was arrested on her front porch, literally the one porch in all Wayne County, in the whole United States. He's not allowed to be banging on the one door, and he's alleged to have been banging on that door. So look.
Your Honor, at this time, seeing as everything that's transpired in the court today, I do not think we have a plea. It does not seem that Mr. Haynes wants to take accountability for what has transpired.
Well, he's saying he's not guilty. No, Mr. Haynes, listen, he's told me he's not guilty. He said he wants to plead because he has a lot, Mr. Haynes. He said he has a life. He wants to get out of custody, so he'll just enter into a plea. I cannot, in good conscience, accept a plea and accept a plea of someone who says, I didn't do it, I just went out of custody. And here's the reality of it, Mr. Haynes, after the nature of the allegation of your violation, it's not like this is a tough one. Okay, it's not where this isn't a case where someone says, hey, he showed up back at my house. This is one where the police were literally called and you were taken into custody at the one place you can't be. You're not getting out. You're not getting out. You're not getting out.
Yeah, but that's on. Sorry, Paul. Yeah, that is specific cases. So that's a no contest plea. When you say you're guilty, you accept responsibility, but you don't plead guilty. But that's a completely different thing. You can't just show up and say, I didn't do it. That would fail a no contest plea as well. You can't say that. Can't say that. Even if this guy is innocent and, he's like, I don't care to have this charge on my record and I just want to get out of jail, so I'm going to plead guilty. Hopefully the judge is going to sentence me to time served and I'll get out. Let's just say that was, what he thought was a good idea. Terrible idea, but what he thought was a good idea. If the first thing out of your mouth is, I didn't do this, I just want to get this out of the way and get out of jail. Yeah, the judge isn't going to accept it. Not going to happen.
Because I can't trust I have to balance your liberty with Miss Weir's safety. And right now her safety is winning because I know you won't listen to bond conditions. You drink.
An Alford plea is a plea that you worked out with the defense and the state where you don't get jail time. So that's what I understand an Alford plea is. So it's not the same thing. It's just you're admitting guilt to it with the expectation that you're not going to get jail time as a sentence. That's what I know of an Alford plea. I could be wrong. Not an attorney. All right, let's go. Let's finish this one.
And then you come around where you're not supposed to be. And I am not going to put Miss Weir's life in jeopardy while this case is pending because you can't listen to court orders. So let's figure out what we're doing.
Ms. Shackleford, can I say one thing, ma'am, please?
No, don't say anything. If I were you, I would not say another word to me. I'm just going to be honest with you. I don't think it's in your best interest to talk to me right now.
Sorry, ma'am. Sorry, ma'am. Sorry, Your Honor.
Because I remember this case and you're not getting out. I can't let you out right now. I think you're a danger to the community. You had one rule.
Yeah.
We'll set it for a jury trial and I'm writing on
No,
your
I'm not pleading guilty, please.
I'm writing on your expedite trial and we'll try and get it on ASAP if that means we have to move some other hearings. Ms. Davidoff, Mr. Gazicki, so that we can get this heard since he is in custody, he should go to the top of the pile or even knock some not in custody trials.
Okay.
So we'll put him on right away. And Ms. Weir,
Yes.
you'll receive notice of that trial date in the mail.
Okay.
Okay, and
Yes.
the prosecutor will reach out to you about that. And Mr. Haynes, I had to mute you, Mr. Haynes, because you're trying to talk over me. I'm not accepting a plea when you tell me you didn't do it. You just want to get out of custody. I mean, that's what you've said, and I'm not inclined to take an offer under those conditions. And I'm not inclined to modify or reduce bond when there is a serious allegation that you went to the literal one house in the entire world you can't go to. Ms. Weir's safety is a concern as well. So we will set it for a jury trial and everyone will get notice of that date in the mail and we will hold that hearing as soon as possible. I will make sure the clerk knows to expedite that trial date. And if that means we have to push something else out, we will.
Your Honor, would
All
the court consider a tether bond?
No,
Okay,
thank you.
thank
We
you.
are all set.
All right.
And can I go
Thank
back
you.
in the breakout room with Mr. Haynes?
We'll put you back in a breakout
Am I-
room.
Am I free to go?
You are excused for the day, ma'am.
Okay, thank you.
And Mr. Haynes, I'm going to put you back in a breakout room with your attorney.
Yeah, Ms. Shackleford, can you, I apologize, Ms. Shackleford, please. I'm just.
No, we're done. I'm not taking a plea on a case. You didn't do it. I'll see you at jury trial. You're not gonna take a plea to get out of jail. I'm just not, that's not what this is about, sir. So I'll see you on your trial date and we're all set. And, officer over at the jail, we're going to put him back in so we can talk with his attorney.
You know, I'm gonna say this. Okay, first and foremost, yeah. If you guys are right about the Alford plea, then I was incorrect. I thought that was the plea where, you know, you're agreeing to a plea with no upfront jail sentence. So if anyone could tell me what I'm thinking of, that'd be awesome. But I've only done the no in maybe a dozen times in my life, and I think 10 of them are to my kids. The no. Stop talking. Judge Shackleford. All right, next case. Moving on. Where are we going? I have no idea. All right, we're here. Let's go.
Okay, Miss Patrick, are you still there?
Yes, sir.
Okay, Mr. Patrick's signing in, so just give me 1 second here.
Unmute. There we go. Think I got it.
All right, Mr. Patrick, are you able to hear me okay?
Yes, it is, sir.
Okay, I don't remember who this judge is. We can see the court name. Is this Judge Mertz? I think it might be Judge Mertz. Anyways, I could be wrong on that. But this case, you know, I'm surprised Law Talk with Mike didn't cover this because it involves divorce and a relationship ending, and it gets really heated. He likes commenting on that kind of thing. So, yeah, let's keep going.
Okay, thank you. We're on the record now in Patrick versus Patrick, case number 2319520. We have Ms. Patrick present by phone. Mr. Patrick is present by video. This is set as a status conference in this case. The last time we met was back in April, and the parties were going to participate in mediation. It looks like you did do that, and it looks like
I don't generally cover Judge Fleischer because he doesn't stream on YouTube, so it's really hard for me to gather content of his. I have one screen, so you gotta, if you watch Judge Fleischer and you cover him, you gotta do it the old-fashioned way. But yeah, luckily, I've been talking with him, and we're setting up his YouTube channel. So hopefully this week he starts streaming on YouTube, so it's not just over Zoom. Okay, let's keep going with this clip though.
we're able to reach an agreement. Mr. Patrick, is that correct from your standpoint?
We were able to reach an agreement, Your Honor, but I don't believe that the terms were met. And I, as much as I want this divorce over with today, Your Honor, I have a few questions.
Okay, what are your questions?
For one, she emptied my buildings and took everything out of 2 different buildings that she wasn't supposed to take everything out of. She shut me down business-wise. She took a sleep number bed that said it wasn't supposed to be taken, which she says is in the building somewhere. She just went about this very, very unprofessionally and poorly and left me in bad standing with the house that she's supposed to give to me. She didn't give me the vehicle titles within 10 days like she was supposed to. Is there any repercussions for any of those actions? And if they're not, then I just would like to be divorced.
I can't get by the sleep number bed. She left him with letters, not numbers. She took the sleep number bed, so all he has left is letters. No, I'm sorry. I shouldn't make light of this. This guy is very frustrated, and you'll see why here shortly.
Okay. Well, to answer your question, I can't really give you legal advice as to, how to proceed if she hasn't complied or followed through with the settlement agreement. That's something that you would need to consult a lawyer about if you wanted.
I have the order to show cause, Your Honor. I have that here, and pictures and damage, and I'm going to turn it in. But if there's no benefit to it, Your Honor, it would be best to just end the marriage.
Well, again, I can't really tell you what to do. That would be the job of a lawyer. And if I give you advice, then I have to give Ms. Patrick advice too. And that's not the role of the court. My
one question, Your Honor, is will I be able to do it after today? If we do get divorced, will I still be able to do the order of show cause?
That depends on a few different things. I mean, well, first of all, we can't go through with the judgment of divorce today. I can't finalize it because that's a document that you would have to submit to the court, and that hasn't happened yet. That's a form. It's called the judgment of divorce. It's the final document that the court signs to finalize things. And so that would need to be submitted. So we can't finalize the divorce today anyway. And again, in terms of whether or not you have legal recourse, I wouldn't be able to give her that kind of advice, so I can't give you that kind of advice either. So what I can do is, I can set this for another status conference. If you want to pursue whatever you want to pursue, you'll need to do that in the interim, okay?
Okay.
Ms. Patrick, I know do you have any questions about going forward? What's your position?
No, Your Honor. I understand that Mr. Patrick feels that I had removed things that I were not supposed to remove, but under the business of Escape the Cabin and through the receipts of the years I've been in business, I had removed my business. This has caught him off guard as he thought a building would include a business.
A joint owned business.
I'm sorry.
A joint owned business.
I'm sorry. I have evidence otherwise, but that is neither here nor there. The misunderstanding of a sleep number bed is not been taken. I saw a white pump in a box that I thought was part of it. I had indicated to his representative that came with us, my daughter and son-in-law, to remove my stuff and my business stuff. I did not take anything that I was not, and I left many things that were.
Oh, there's lots of
I-
garbage left.
I would be more than happy to put effort into cleaning, but I did not wish to stay longer than I needed to.
You are not allowed in the building if I can say anything after what you've done to me.
All right. You know,
I do, Your
I don't want
Honor.
to get into it. I don't want to get into a debate about what has or hasn't happened yet,
Correct.
because it's really not the point of this hearing today.
May I?
Go ahead.
I have completed all of the paperwork. I have the titles and the keys. I have them here. I have done this before with Mr. Patrick in February to find him failing at transferring it out of my name, driving with my plates and insurance. I had only asked that we waited till the last minute. He has, at my last contact at the Register of Deeds office, he has not completed the paperwork that he agreed. I have filled it all out for him. I have set up the insurance to be transferred and contacted with him. I have done what I can do. I did not ask for this divorce, but I would like to move forward in it.
All right, well, again, I'll set this for a status conference in 30 days. I would encourage the two of you to try and work out whatever these issues are between now and then. If you're able to do that, then we can finalize the divorce. If you're not, then the only other way that the court's going to have to move forward is to, set this for a hearing. And just looking through the settlement agreement, it looks like there's a lot of assets. This is the kind of case it's complicated enough that the two of you really ought to have some legal counsel helping you with this, so that, number one, you're able to present your cases effectively before the court, so that I can make a good decision. And number two, to advise you of your rights and what your recourse are, because I think the two of you have a lot of questions and issues about that part of it.
Your Honor, are we only not getting a divorce because he failed to file for the judgment paper?
No, it sounds like you guys don't have an agreement. It sounds like there's a lot of issues still out there. So
Complete agreement that has been performed right up until these last few days.
well,
And I
Mr.
believe
Patrick saying
strictly
that.
verbiage.
So here's the problem. He's saying there's things you were supposed to do that you haven't done, and you're saying there's things that he's supposed to do that he hasn't done.
I'd like to say something, Your Honor, if I could.
Yeah.
Everything is
If I could just say something, Your Honor, the paperwork
Yep.
that she's talked about has been completed. Everything has been completed. The Sheboygan paperwork cannot be delivered to Sheboygan for title work. She will have to do that herself, just like I will have to do to the Ironwood. The only thing that has not truly been completed is I just found a power bill for one of the addresses that I have to get up to date. But short of that, the stuff that she's talking about, I have completed. She just doesn't know because I just did it.
Yeah,
Thank you, Your Honor.
Yeah, Jedi. You know what I love? I love can I say something? Can I please say something? And before you even get a response, you just start talking. Can I say something? Please, can I say something? I did everything that I was asked to do. She's the one not doing the stuff. And oh yeah, was I allowed to talk? Yeah, yeah. Both of these people need to be put in timeout. Where's Judge Stevens? Put him in the jury box.
I understand that's what you're saying.
I did it. I have it.
I don't know who has actually done what at this point. You're both telling me that you've done everything you're each supposed to do, and the other one's saying that you haven't. So,
well,
I can show you it. I have it. I can show you it, Your Honor. It's right here.
Well, the whole point, again, if you're not able to reach an agreement and, hammer all of these things out between the two of you, I have to have a hearing where you come into court, you present evidence. I have to make determinations about what that evidence means. You can't just hold stuff up in front of a camera, and I can't just go on everybody's word. So that just opens up a whole different process that we have to follow. I can't just make informal decisions based on what you guys are telling me here.
Okay, Your Honor. I can tell you, Penny, I did do this work and I would follow through with the judgment if at all possible. How it is written, how it stands on this very day, I believe that we are 99.9% okay, Your Honor. Do I feel that there might have been a slight to me? Sure. But I am willing to concede at this time. You tell me which paperwork to sign, Your Honor, and I believe that she would feel the same way, and we can just be done with this at this point with no changes to nothing, no how, nowhere. I'm okay with.
Okay, so Mr. Patrick, you're the plaintiff, and it's usually the plaintiff that submits the final document. That document is called a judgment of divorce. You can find that. It's a form that you can find where you got the same forms to file for divorce.
Okay.
And that judgment needs to be filled out, and it also needs to have attached to it the settlement agreement that you both reached through mediation.
Okay.
And then I'll set this for another hearing, and that needs to be submitted to the court before the next hearing. I will send you both a notice of the date and time of that final hearing, so you'll know about that ahead of time.
Very well. The sooner the better. Thank you, Your Honor.
All right, Ms. Patrick, do you have any other questions?
No, Your Honor. I will leave these items, keys and stuff at the location. If
All right,
that is
that's something that you and him need to work out. I'm not going to get involved in that. That's not part of my role.
We have no questions other than I'm waiting.
Okay. Mr. Patrick, you also need to send a copy of that judgment to Ms. Patrick as well.
She has it from mediation. The judgment of divorce. Yes. Yes, Your Honor. And can I just mail that, or does it have to be served?
It has to be served. And that way we'll all be looking at the same thing at that next hearing, so we can go through it. Okay. All right, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Thank you.
All right. And right now that judge is wondering why he entered the idea of family law. Anyways, let's go. Let's keep going. I got a lot of good ones. We're only 2 down. Still like 3 or 4 more to go.
It's now back.
Oh, and now we got a civil case with Judge Washington. Yeah, Judge Washington. Let's go.
Session. The court will call the case of Credit Acceptance Corporation versus Vanessa Mendoza and Kelsey Linderman. Case number 23C 3792.
Good afternoon, Your Honor. Brant Lashinsky, P84238, Pentic, Cover, and Kobalak. I'm here on behalf of Ms. Vanessa Mendoza. I'd like to just update the court. She's been recently married. It's Vanessa Pokoy, P-O-K-O-J.
Thank you.
If I may, Your Honor, she did it.
Sorry, guys. Can't fix her. She just got married. Just saying. Anyone out there that was about to put that comment down, you can't fix her. She's married.
Attest to that in the affidavit attached to our motion for summary disposition.
Thank you. Mr. Andrew Cates was just allowed into the courtroom. Mr. Cates, please unmute your device and state your name and your appearance for the record.
Yes, Your Honor. Andrew Cates, P78292, standing in for counsel of record, representing Credit Acceptance Corporation.
Thank you. All right, we're here today in this particular matter because the defendant, Ms. Vanessa Mendoza's attorney, filed a motion for summary disposition in this case. It appears to me, Mr. Lazinski, that the attorneys have, in response to your motion, submitted a copy of the actual contract that was involved in this case. Is that correct?
It does appear to be correct, at least allegedly, Your Honor. Yes.
All right. Yes, allegedly, because your client denies ever signing any such documentation. So, you may proceed with your argument as to any other requests. I think that the issue for this court is, I think it creates a clear issue of fact regarding whether or not she signed that document or didn't sign that document. She's obviously submitted an affidavit that I've read that says she did not co-sign and she did not sign this document. It is not a co-sign situation. It is, but she's actually the main debtor in the document and not a co-signer to it. As I read the document, am I correct about that?
If I had reviewed that document as well, Your Honor, and to me, and I read it as such, it says buyer name and co-buyer. So I don't think it assigns a priority of signees, so to speak. So I would consider them both, according to this document, co-buyers, such that they both have.
Have a good night, Doc Ock. Oh, I think I just unplugged my mic. Hopefully you guys can still hear me. Doc Ock, have a good night. Enjoy your rest. You deserve it.
Theoretically, the same responsibility.
Gotcha. I agree.
May I speak on our attempt to contact the second possible defendant, Miss Linderman?
You may.
Well, Your Honor, we've had multiple attempts to serve Miss Linderman. I believe she has an alias as well. Her first address we had searched for came up as no forwarding address. Resident moved. The second address said no change of address on file, and there was a gentleman at the house who was quite aggressive with the process server. After several attempts, the process server left a card and received an aggressive message telling him not to ever come back. But we did file a motion for a second summons, which was accepted, and the second summons is due for expiration by July 24th, according to my notes. So we have not been able to locate the other defendant. However, part of our argument is in such that plaintiff should be actually, at least in part, seeking this co-signer to the contract if indeed it is legit. As to our motion for summary disposition, as Your Honor stated, it's become somewhat procedurally awkward in that when the complaint was filed, and as I've spoken to in my reply to their response, there was no attached contract attached to the initial complaint. When our offices contacted counsel's office for a copy of that complaint, they refused to give it to us and said that they would not turn it over until discovery was ordered. Okay, so to us at that point, that made sense to file the motion for summary disposition. We had no document or instrument connecting our client at that point to the transaction. In counsel's response to our motion for summary disposition, as Your Honor obviously knows, there all of a sudden is this contract document attached. Further, in their response, they state twice that it was attached to the complaint. We did double check with the court to see if it had been missed or lost somewhere. It was not ever attached to the complaint. So admittedly, assuming, let's say, for argument's sake, that this is a legitimate document, we had no awareness of it, nor did our client, and hence we filed our motion for summary disposition. Our request in that reply, should this case go forward, I'm happy to see counsel showed up respectfully. There's been some frustration since the very beginning getting communication with brother counsel's firm. But we think our position with our reply, Your Honor, is that there's been a lot of cost that has been attributed to Miss Okoye Mendoza that could have been avoided had counsel sent us over a copy of the instrument from the very beginning, as we politely requested. So the motion, none of these hearings would have necessarily been required of our client had counsel been willing to work with us on the document. That's kind of my closing, that is why we asked for sanctions in our reply. As this case may have to go to trial due to the fact of this instrument providing some type of evidence in question per the motion for summary disposition, I understand that some of this may need to wait.
Thank you. As to the amount of your request for sanctions?
We asked for $2,500 in our reply. Our clients incurred about $3,168 in defending herself in this matter. We have $40 in court costs, and we've asked for sanctions of $2,500. So total would be $5,708.
What is the amount you spent on this motion, Mr. Lisinski?
We'll have to look. I don't have that figure right in front of me, Your Honor, but I probably can see it in just a matter of moments here.
Right, thank you.
Basically, the motion itself, let's see if I can see it. Okay. Moment. Probably, yeah, on just our motion and our reply. Estimating for expedience of the court, Your Honor, 1,500.
All right, thank you. Mr. Cates, what would you like to say in response, sir? I have looked at the complaint myself. I understand your standby counsel or stand-in counsel, but I've looked at the complaint myself and I don't see where this contract was ever attached.
Your Honor, from the notes I'm reading, the counsel of record has told me that the complaint was attached. If it didn't make it into the court, then I don't know what to say to that. However, the plaintiff's position on this whole thing is that at least at the time, I know this is changing now due to the circumstances of this case. It was plaintiff's position not to provide documents until discovery was ordered, so it could be done in an orderly fashion, and we wouldn't have to produce multiple copies for Anyways, so that being said, I mean, there was no discovery at the time this case was initiated, and it seems to me, with all due respect to brother counsel, that he just pretty much jumped the gun. Instead of asking for some discovery and making a formal request, that he files a motion for summary.
I'd like to respond when you're done, Counselor.
There's no need for a response.
Yes, ma'am.
Anything further, Mr. Cates?
I mean,
Oh, Mr. Gates is trying so hard right now. He knows what's coming. He does. He's standing counsel. It's not necessarily his fault, but he's a part of the firm that dropped the ball. Just look. When you pause at the right time, when Judge Washington's just scowling at somebody, you know what's coming. You do.
For what opposing counsel has said, I mean, we thought that the contract was attached to the complaint.
Well, there's the problem. There is the problem that I have, Mr. Cates, and it's not with you. I understand your stand-in counsel today. The complaint itself, I'm reading it, says right here in the complaint on item number 2, plaintiff's claim is based on a written instrument which is not attached as it is in the possession of the adverse party. So the response that was provided to this court is absolutely incorrect. And it is clearly written in the document that they filed. And not only that, but when counsel requested a copy of the contract so that he could adequately defend his client, I have a letter here where they said they wouldn't give it to him because discovery hadn't been ordered yet. That is not the way these things are supposed to work. There was no common courtesy in that. I don't feel like he jumped the gun. I felt like instead of him waiting to cost his client more monies, if you don't have proof that she was involved in this matter, he filed the appropriate motions. I do think sanctions are appropriate. I've never done it since I've been on the bench, but this is one of the cases in which I do. Now, as to the amount, that's a different question. First of all, the motion for summary disposition is denied for all the reasons I placed on the record before. There clearly is an issue of fact as to whether or not she was a party to this contract or not. I think the parties are going to need to look into, from what I have here, is an electronic signature. I don't know how those come about, how that happens, and she's denying that she ever did it. So that is clearly a question of fact for the trial effect in this particular case. So therefore, the motion for summary disposition is denied. As to the sanctions, I am not happy with the way that this matter was handled by original counsel for the plaintiff in this case, not you, Mr. Cates, but the fact of the matter is when he asked for a copy of the contract, which they clearly had since they produced it as soon as the motion for summary disposition was filed, they could have given him that and we wouldn't be here. So based on that, I am going to give them sanctions in the amount of $1,000. We need a pretrial date.
Unless we can dismiss this today.
No, it's not going to get dismissed.
Okay, thank you, of course.
I understand why you want that, but
No objections, Your Honor. Absolutely respect that position.
the
Dude just tried to double down on his win. And maybe some judges would have thought that was a funny joke, but yeah, Judge Washington's not happy. First off, stand-in counsel was held out to dry, and hopefully it wasn't intentional. But if I was stand-in counsel right now, I'd be pissed. If you just put me in front of a judge, and you know what? We just saw it happen. I don't have to summarize it. All right, let's finish this clip up.
I can give you a pretrial of you want 30 or 60 days, and since discovery is such a huge issue, looks like we're going to need some in this case, some real discovery. Do you want 60 days or 90 days for discovery? What do we need?
My inclination, Your Honor, would be 60 to 90 days on this particular matter. I leave it to the discretion of the court, or maybe opposing counsel has another opinion.
No, I agree. 60 to 90 days, particularly, Your Honor, in terms of the fact that I would hope Brother Counsel and his firm may be able to help us in this, but it would be helpful for all parties if we could get this Ms. Linderman properly served and party to this action. So 60 to 90 days is going to be.
No, that's not on the client. The sanctions are on the attorneys. That's what a sanction is. You're sanctioning the attorney for, essentially wasting the court's time. And it's like a fine. It's kind of like when you hold a attorney in contempt, but you're not holding him in contempt because contempt actually like that follows you around. But if you're just sanctioned for something, it'll go against you. But yeah, it's just a fine. No, that's not the client's fault. It's not the client's fault that her defense attorney didn't, send the contract over. They didn't send the evidence over when they're supposed to. And now they're in a hearing. So the judge is pissed because they just wasted, what has this been? 25 minutes of the court's time. And it's because the attorney didn't do the right thing. And then the attorney held this poor guy out to dry for stand-in counsel. And yeah, I also don't know what you mean by you watched the original video. You mean from the court? The original content creator, yeah, Judge Washington. Is that what you meant, Allie?
So that date's 7/24 for the second summons to expire. Let's see where we're at. That's about 60. Let's go somewhere between 60 and 90 past the end of July, probably.
I'm gonna go to August 29th.
Okay.
August 29th. Well, actually, what I'm gonna do is go to. I want Discovery to end like a week before then.
You want to have on a Friday?
Thursday.
One exact week would be 22,
Okay.
August 22nd.
Discovery through August 22nd. 2024. We'll do a pretrial, another pretrial to see if we're ready for actual motions for summary disposition or whether we're going to be going to trial.
Okay.
And that will be on August 29th, 2024 at 2 p.m. Please have counsel have someone ready to go and here at the actual time that the case is supposed to start. Today, we had to wait 20 minutes for you to show up, Mr. Cates. I don't know if that's because they didn't communicate something to you properly, but.
No, that was my fault, Your Honor. I apologize. I was wrapped up taking care of another matter, and I do apologize for that.
Okay, thank you. I appreciate it. All right. We're all set for now. I hope that the parties can talk and try to see if we can get to the bottom of what happened in this matter. So, I don't take any position on who's telling the truth or not telling the truth, but I want to get to the truth. Okay, so let's try to make that happen.
Yes, ma'am.
All
We're
right.
happy
Thank you, Your Honor.
to talk about alternatives.
All right, thank you. Bye-bye.
Thank you.
All right, moving on. Moving on. You know what? I don't know what we have next. Oh, this one's fun. This one's fun. This is, this is in theme with the thumbnail where defendant's really not happy. This happened. This might be the only clip that happened today I have in this video. Everything else is within the last couple days. So let's go.
Okay, now calling case number 15W003475. This is the Township of Ypsilanti versus Tate Bellingham. Can you please unmute and state your name for the record?
Okay. Can you hear me?
Yes, I can.
Tate, Ryan Bellingham.
Okay, thank you. So today is the date and time set for a show cause hearing in this matter. So this is a citation from August 6th of 2015 for parking in a fire lane. Your
Right.
balance on this is $132.
My question is, I've never gotten any notification about this in the mail at all. And it's why all of a sudden 10 years now I'm getting this notice in the mail saying that I need to appear. I don't even know anything about this ticket.
Okay.
Dang
So
Ellie.
okay. So the ticket was issued August 6th of 2015 at approximately 12:47 in the afternoon. And it charged that you parked a motor vehicle in a fire lane on Whitaker Road at or near Stony Creek. So it looks like there was an initial court date back in December of 2015. And I don't have a note on here as to whether or not you appeared for the date back in December of 2015, but in any case.
No, like I said, I wouldn't have because I didn't know anything about it. I was at a bad time back then. I might have, I know I loaned the car out to people. So, I don't know anything about this ticket whatsoever. Otherwise, I would have handled it.
Okay, well, at this point.
And then I don't even live at that. Oh, go ahead.
Okay, so I was going to say it, the address we have for you is Union Street in Belleville.
Yeah, I lived there until 2017, and then I moved out. So,
Okay. How did
I
you,
mean,
how did you find out about the hearing today?
well, like my mom still lives at that address.
Ah, okay.
So she let me know that I got it. So that's what I'm saying. If I had got a notice in the mail, she would have called me and said, "Hey, you got a notice in the mail." That's how I
Okay.
found out about this one. And luckily, I found out about it because I drive a truck for a living, and I rely on my driver's license. I'd ended up with a warrant if I wouldn't have gotten this notice to appear. You know
Okay.
what I mean?
Well, and I,
All right, this is this is when this guy, his demeanor is about to change. I think he believes that because this ticket is 10 years old, it's just going to be dismissed, and this is just a formality. Oh, wait, just you wait. And yeah, no, I saw a couple comments. Why are they sending these notices out 10 years later? I would be frustrated too. But at the same time, you don't forget about a ticket you have. And he just admitted to it, right? He's like, oh, I may have done that, whatever. And yeah. And so he admitted to it, and now he's about to get upset. But we got through the friendly side of the hearing first.
agree with you. I don't know what to tell you as far as whether or not the notice went to you 9 years ago. I have absolutely no idea. So, it looks like we had that same address for you on file since the ticket was written. So, in any case, the balance is $132. When can you have that paid?
Yep, that was the look. That was the look where he's like, "Oh, this is going to be dismissed. This is just a formality." Nope, $130. Not the worst ticket. It's actually, as far as ticket goes, I think that's pretty inexpensive. But yeah, when it comes out of nowhere and it's not coming out of nowhere. Okay, I'm gonna stop talking.
Well, why is it? What was the original price of the ticket?
I don't know, but I can tell you right now that the balance is $132. And the time to fight over it would have been about 10 years ago.
Well, and I would have if I would have known about this. I didn't know about it.
Okay.
That's what I'm trying to explain to you now.
And
And
so I hear you, and I can appreciate that you're annoyed at the fact that you're finding out about a ticket from 2015. But at this point, I've got the citation. If you want to come to the courthouse and ask to take a look at it, that is perfectly fine. But I've got a balance that's due for you of $132, and I'm asking when you think you can have that paid.
Well, I don't have $132 to pay it, so I can give you. I got about $80 I can pay.
Okay.
I don't have $132 just to. I mean, a lot of people might, but I don't.
All right. So welcome to Let's Make a Deal. That's not what this is. Yeah, I can give you $80. Give you 80. How about 75? You know what? If you round it up to $82.39, I can cover that. Yeah.
So what I will do is set you for another court date on August 27th. Okay. If the full amount is paid off by that court date, then that date will be canceled. You won't have to come. But otherwise, if you're able to make partial payments between now and August 27th, then that is what you should do. Okay.
Let me ask you a question. What would you have done if you just sent it? I mean, because it's been 10 years.
Yeah.
10 years since this ticket. I've never gotten anything in the mail. Now all of a sudden, 10 years later, I'm getting a letter to appear. I never gotten anything. Know nothing about this ticket. And now you're telling me that I got to pay $132.
Yes.
Or I'm going to get my driver's license is going to get taken from me.
That is 13 games. 13 games. I can bowl 13 different games with $132. You're taking away my free time now. How dare you, magistrate? How dare you?
Well, no, because the laws as
I
far
have a
as
warrant for my arrest, correct?
You do not.
I would if I didn't appear today.
Potentially, yes.
Right. And
generally
you guys
speaking,
are just sending out. Why did it take so long to get this?
At this
Why did
time,
it take so long?
I don't know what to tell you. If you want to call into the court and have a longer conversation with us, then you can do that. However, I
We
have
can
other
you
people
guys
who
are
are
something
able
else,
to-
man.
What's the number? What's the number of people?
Wait 10 years.
Where's the original proof that they mailed it to you?
Yeah, he hung up. He hung up. Gone. And then he heard his wife, or I don't know why I said wife. I just assumed it was. Heard the female voice in the background. What's the number? What's the number we can call? What's the number we can call? Yeah. 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 You did it, man. You admitted to it. You admitted to it on the record. You're not going to be able to fight it. You're going to have to pay the $132 for, what was it, a broken taillight? Was that what it was? No, it was parking in a, he parked in front of a fire hydrant, an emergency zone. That's what his ticket was from 10 years ago. Yeah, man. Got to pay your ticket. He's lucky that his license hasn't been suspended already. I remember one of the very first tickets I ever received. I was driving my parents' car, and I got a ticket and I just put it in the glove box. At the age of 18, 19, I just didn't, whatever, just let it go. Like, I didn't care, and I didn't think anything was going on. Like, about 3 months go by, and I think it was like a family dinner. My dad went off on me because he got a letter. He got a letter that said, your license is now suspended until you pay this ticket. So my dad lost his license for a day until he paid the ticket, and then I had to pay him back. But 10 years? That fell through the cracks somewhere. I understand why he's mad, but he didn't pay the ticket, and he admitted to it. So, yeah. Sorry. Dude, pay your ticket. All right, next one. Next one. Where are we going next? Where are we going next?
Thank you.
Oh, this one's fun. You know what? This might be the last one. I think this is a little bit of a longer case. This is another civil case. I should have just titled this video civil cases, because that's what most of them are. This one's fun, though. I am very much looking forward to everyone's opinion on this.
For being patient. All right, Formula Reps, go ahead and give me a brief overview of why you're here and what you're asking for.
Yes, ma'am. So I did some work for Joshua here on his car. We did a chrome delete package, and we also did a brake caliper wrap on his car. So typically I ask for a 50% deposit before the job starts, and then 50% once the job is complete.
Okay, so you did a chrome delete and a wrap.
Yes, a wrap in his brake calipers.
Okay,
correct.
go ahead.
So prior to doing the job, we did a walk around the car, and we talked about expectations, what to expect. I did explain to him that it is a wrap, it's not paint, so you may not have full coverage like you normally would with paint. There's some parts of the brake calipers that you cannot wrap, simply due to the moving parts and the grease that's in the brake calipers. The wrap just won't stay. So he paid the deposit. I did the job. He came to pick up the car, and he wasn't satisfied with his brake calipers. He said, well, I thought it was going to be the full coverage. I explained to him, hey, we talked about this. This is what this looks like, it's expected. He said he wasn't happy. So I try to do everything I can so that the client is happy. I don't let anyone leave unhappy. So I offered him 2 different options that we can do. They were both expensive options for me. I was going to take a hit on that, but I was going to do it at no charge, just so that he can be taken care of.
Okay.
and leave happy. So with that said, he agreed, and he told me to go ahead and give him a date when he can bring the car back, and so that he can drop it off. I told him that I'll even cover the rental car for the time that his car is still at the shop. I'll pay for the rental car as well. So he leaves the shop and then never, paid the payment. So I called him a few minutes later and I said, hey,
So he never paid the second part because he
Never
only
paid the
paid the
second part.
50%.
Correct.
Okay.
So I said, hey, are you going to be, paying the remaining balance? He's like, I'm not going to pay that. I'm like, I'm sorry? He's like, yeah, I'm not paying that. I'm not satisfied, so I'm just not going to pay it. I said, well, that's not what we talked about just now. You say you're going to bring your car back on Monday. I'm going to get you a rental. We're going to fix the issue and you'll be on your way. And he said, no, I'm not going to come back. I'm not going to pay. So I said, okay, I'll take you to court.
So what was the total amount?
The total or the?
Yeah, the total amount that he owed you, because he only paid 50%. So
correct.
What's the total amount that was owed?
So $946.13.
946.13 was the total amount, correct?
That he still owed.
Oh,
correct?
this is what he owes you.
This is what he owes me. That's not including the late fees and the court costs.
Okay. So then the bill was 946 times 2, so it was about almost 1,900,
That is correct.
give or take.
That is correct.
Give me 1 minute. All right, Mr. Joshua, go ahead.
Morning. Just as much as I can. It was around 24 January.
This is another small claims matter, a civil matter, and Chrome Delete was the name of the package. So this guy, the white dude, he wraps cars. He owns a company that wraps cars, and black dude paid him for his services, but he only paid 50% of the service. So Chrome Delete was just the name of the package he bought to wrap his car. Hopefully that helps.
I sought out Former Wrap to perform the wrap and the Chrome Delete. The first service, Chrome Delete, then the wrap. Total invoice was the 19. 50% was paid up front 2 weeks prior to the work starting.
Okay.
Dropped off the vehicle on February 6th with a pickup date of February 9th. Upon returning to pick up the vehicle, we did do a walk around inspection of the work that was performed. That's when I informed Mr. Bylov, hey, the calipers did not meet the expectations of what he said he can do. We went back and forth verbally as far as my displeasure with the work that was done and him trying to explain that, hey, this is the best that I can do, et cetera, et cetera. So at that point, me and Mr. Bylov agreed to say, you know what, since I'm displeased and dissatisfied.
Aaron, I'm sorry for pausing it right in the middle of this, but I agree. You know, a really good wrap job looks really good. It does, but it's temporary, right? So you're putting a sticker on your car, it's temporary. So they look cool temporarily, but then you gotta keep doing it. Yeah, don't like it. You know, it's like when you put a screen protector on your phone and it starts bubbling up. You're gonna have to remove it and get it replaced. It's just, you know, they look cool for a little bit, but that's it.
Satisfied, I will take my vehicle elsewhere and get this work corrected because what he explained was if he removed.
But he's not him.
No, yes.
Okay,
He
okay.
explained that if he's to remove the material he put on the calipers were not in the state that I brought them in, since the original job was to break down, dust, prime, and remove the dirt and the debris prior to starting work. He explained to me that in the process of doing that, it altered the appearance of my original calipers. So I said, okay, you can't return the calipers back to the original state, but you can take your material off. Once again, we're back and forth until we got to the point where it says, hey, since I have to redo this, I don't longer trust integrity of your work because you had my vehicle promptly for a week. You could have explained to me that you were running into complications with the wrap. That could have let me know what to expect on the day of pickup. So we agreed no more monies was owed because now what I'm gonna have to do out of pocket to correct this basically would have been the amount that I would have paid the day of
Okay,
pickup.
but you didn't get none of that in writing, as far as there was no money owed anymore, because that's the key point of this whole conversation.
Okay, yeah.
Okay, so, because he's wanting the other 50%.
Yes,
Okay,
I understand
and
that.
you're stating that y'all spoke, and due to all what you just stated,
Mhm.
that y'all were agreed that it was an even, the 50% of what was already paid was gonna be enough, according to what your conversation is,
Yes,
right?
ma'am.
Okay, but was any of that in writing? Because if that's in writing, the case is over.
No, that was verbally
Okay.
between.
And do you see wherein lies the problem? Because of course, when I ask him, he's gonna say no,
I
because
have-
otherwise that's why we're here in
Okay, I
court.
do have in text messages.
Let me see that then, because that's gonna stop the case dead in its
Now,
tracks.
the text message is verbally between me and him. He didn't, in the text message, he did not acknowledge
Okay,
the agreement, but that, I have that in text messages. And not to get off story, I also
okay, go ahead,
have,
go ahead.
from the district attorney, I have harassment charges, stalking charges, video footage of him driving by my residence while my children are playing outside. In addition to the letters that were sent to him to cease and desist contact in my workplace, they're not here present, but if need be, my HR department.
Well, you have that already with the district attorney, is that correct?
Yes, ma'am.
Okay, that's a totally separate case, that has nothing to
Okay,
do with us.
understand. Okay, so here, messages, text messages between.
And so, Mr. Joshua, you're not denying that he did do the job. You're just not satisfied with the job. Is that
Yes,
correct?
and as part of,
Anybody have a picture of the vehicle?
I have pictures.
I'm like, I have yet to see the vehicle.
The vehicle entirety, no, I just have pictures of the brake work that was done. So this is all what he. And you'll see this car. This is, the red is before, this is current.
So the car was wrapped in white or?
No, the brake calipers were wrapped in red, reflective red, and the chrome trim that he had on his car was wrapped in gloss black.
His issue was he didn't like the calipers.
He likes the calipers, correct. Now, mind you, I've done this, I don't know how many times already. I've never had a single issue from any other client. If you look at my reviews on Google, you'll see that everyone's happy with my work and the work that I do and the pride that I take in my quality. So for him to say that is just, it's,
Dorina, I love how your brain works. Your brain is beautiful. And that is the comment of the night. I laughed out loud when I read that. And I feel ashamed that I didn't think about that. And this is, I think, the third time I've seen this clip now. So, yeah, thank you so much for that, Dorina. Winner, winner, chicken dinner.
inaccurate.
Yeah.
Also,
thank you, sir. And okay, so correct me because you're gonna have to explain it to me like I'm a 5-year-old. So this is what the issue is.
So the issue is, ma'am, that the original color that you can see is it's like a color distortion. You see a red, but then you also see like a cinnamon or amber. That was the original color underneath that was supposed to be removed. That color was never removed. He just went over the top.
Okay.
So now both colors are exposed to where you see the discoloration.
Okay. Okay. And is that correct that it was painted over, not taken off?
It was painted over the OEM, and so when we tried taking it off, some of it came off, but some of it didn't. It stayed on. And for me to wrap something, I do what I call the gas mask test. I put a piece of vinyl on the paint and I peel it off. If it rips the paint off, I can't wrap the vehicle, period. So when we did the test on that part, pretty much 80% of it stayed on there and only some of it came off. So at that point, I said, okay, well, this is not coming off, so we can go ahead and proceed with wrapping.
And then what is this?
That's all the red, that's all the red that he did, and you'll see the yellow, which I had corrected and done.
I was gonna say, I see a yellow. So
Yes, yep.
yellow is what you have on now
Yes, that I have receipts from a different auto shop.
from somebody that did it.
That
different.
corrected the work, correct.
And you were satisfied with that one?
Yes.
And so this is how it was dropped off to you?
No, once I got it back and I took it to the next shop, I had them say, hey, can you give me a breakdown of what work, like what the work that was done? And that's when it was like, hey, this is already peeling. And they.
That's what I'm saying.
Yes.
This was already peeling from.
Correct.
Yes.
So when we were doing the inspection of the brake calipers, when he was pointing at the issues, he literally got his nail and started peeling the wrap off. I said, well, yeah, it's peeling off because you're peeling it off. And so that right there is from him peeling it off with his finger, yeah.
Your Honor, that's actually not so, because I can't peel off with the wheels on the car. That's actually in a shop, wheels taken off, and photographs taken by another shop to show, hey, this was the work, this is how it looks as we're now undoing what was done prior to repainting in yellow.
And then this as well?
Yes.
Same pictures, just different
Yes.
positions?
Yes.
Okay.
Your Honor, I do have a video on my camera footage at the shop where he's kneeling down and he's going with his finger and literally peeling it off.
Okay, I'll see it in a minute. Give me 1 minute.
As you can see, when you look at the yellow for work that was done, it's night and day, Your Honor.
And so they took off all the red, I'm assuming.
Yes, ma'am. Completely primed, breakdown. It's on the invoice that they gave that I have here for the amount.
Let me see the video real quick.
So since it was primed, that means it was painted, right?
And that was exactly
so the
what your
video,
point was, that you did a wrap and it's not gonna be the same as a paint.
But that was never told to me, Your Honor.
It was the initial inspection of the vehicle when you first dropped it off. It was that. Ma'am, so on the videos, can I submit that to you later? Because I have to go through the footage
Okay.
and literally crop that
Well,
section out.
yeah.
I do have it. I
Well,
wasn't ready
today's
for
in
for
court,
that.
so that's what I need right now. from you, So, because I'm pretty much guessing you're not inclined to a reset.
No, ma'am.
Okay, that's what I figured. Okay. All right. So does anybody else have anything else to say?
Furthermore, Your Honor, as you can see within the texts that's going on between Mr. Bala, it was one way. The Texas went to the extent of within a 4-day window, calling my job, harassing my job, to where HR had to let him and his associates know they cannot contact my place of business. I'm a 22-year vet. I work for the Department of Defense, and that started breaching the line of her, like I said, the
Oh. Yeah. Sorry, dude. When you start name dropping the company you work for, think it's gonna hold any kind of thing in court. That's when I say cringe. I don't like this guy. We're more than halfway through this clip, and I'll tell you, I do not trust the. Is he the defendant? I don't even know. The guy who got his car wrapped. I don't trust him. I don't believe a word he's saying. But he's dropping, I work for the Department of Defense. I've got military clearance. Yeah, no, I did too. I did too for a year. You know what it meant? Nothing. You know what it took me to get that job? Almost nothing. I knew how to code. They looked into my background. I didn't have any felonies. They hired me. Congratulations. Doesn't mean you're a good dude and doesn't mean you're telling the truth.
harassment and other things that this all ensued within a week's window. So the texts are him intentionally saying, hey, I can get your security clearance removed because of this, et cetera, which was me taking as threats like, hey, we agreed that this was a wash and I was going to get the work done elsewhere. Your level of aggression now to recoup this payment that we agreed wasn't going to happen, you're crossing the lines, and that's what led, as we said,
To your district
yes.
attorney. Okay. Formula wraps?
Yes, ma'am.
Do you have anything else to say?
No, pretty straightforward.
And one more thing, Your Honor, if the timestamp from the time I got my vehicle back, it was less than a week later that I got to another shop and had the work done. So it's not a matter of if I was parading around with his material, anything on the car. And within less than a week, I got it corrected. I had that receipt here to.
And do you have any return policies or anything?
No return policies. I do offer the 5-year warranty on the film and installation. So if anything happens to the film or the installation errors, then you're covered for 5 years, fixed at no cost to you.
And you said these pictures were taken at the shop that you got it done at Auto Salon?
Yes.
And then again, Formula One wraps, you are denying the whole conversation where y'all were gonna wipe everything clean.
That is correct.
And again, you don't have nothing in writing or in text
No, ma'am.
about that conversation. All right, so the total amount that he's seeking is the initial $946.13. That was the remaining balance. And then he added late fees of $450.
Well, that was $25 per day.
$25 per day. Okay, so the balance that he is seeking, I guess, was $1433. Is that correct?
So at this point, it's higher than that. I mean,
Legal fiction. I know I brought this up. I don't know if I actually called you out. I don't know. I don't think I did. Legal fiction, thank you so much for the 10 gifted memberships. I appreciate it. That's very generous of you. Thank you. Welcome to all the 10 new members. You are awesome, Legal Fiction. I appreciate it, buddy.
That's fine. Give me 1 minute. So we're at 9:46 of initially of what is owed, and then despite the late fees and everything else. Okay, so I am looking at the pictures and I'm looking at the conversations.
Your Honor, I'm familiar with the text, and as you can see, his initial text saying I came to his place of business with that mentality.
I was
took-
just reading.
Yeah, that insinuates of some form of discrimination, saying what mentality would he be insinuating by that? When I paid half up front and I came today to pick up my vehicle to pay the remainder, but I was dissatisfied with the work.
Shut up, dude. Shut up. Just stop talking. Stop talking. Yeah, again, I trust the business owner. I do not trust this guy. I don't. You know, he wrapped his car and he wasn't happy with the calibers, but the business owner said up front, we don't do the calibers because it's really hard to do, and we can attempt to do them, or whatever verbiage he used. And that's what he's using to not pay? No. You don't, it doesn't work. You're trying to get out of paying for half of your car wrap, which again is a luxury item. If you can afford to do a car wrap, pay for the car wrap. This guy, the business owner, I'm guessing he's probably pretty new in it, where he charges half up front and then half at the end, instead of just paying for it all up front. That seems like something that, I don't know. That just doesn't seem like the best business model to do for this case. But yeah, I don't know. I've never wrapped a car. I've never had a car wrapped. I have no idea what normally happens. But it's such a luxury item. Yeah, I don't trust this guy. I don't trust the defendant.
So explain that part.
Go ahead.
So originally when he first came up, pulled up, normally I greet people, hey, how's it going? Welcome back. Here's your car. The first thing he does, no eye contact, no handshake, immediately goes to the car and just starts doing this, like looking for stuff. He's doing that for a good minute. And so I'm like, hey, is everything okay? Like, are you all right? Like, is there an issue with the wrap? No, just looking. No, he kept doing that whole time. So that's why I said, later on started to think it's like he already had the mentality of not paying me. He was looking for something.
What is going on with the text assist? Did I miss something? Is that how he pronounced texts? I'm guessing it is, because everyone's been saying it. I missed it, but you guys have all been saying it. I need to rewind and go see what you guys are saying.
Not the first wrap shop that he's done that to either.
What do you mean?
He said worked on the previous shops before, a couple of years back, and speaking to the owner, he did the same thing. They never filed the case because it wasn't worth it, but they did the same thing.
Yeah, the Better Business Bureau, the BBB, does do something. Now, just think of it as, to simplify it, they are the health food. What is it? When you work at a restaurant, you get the health inspectors in, and they give your restaurant a rating. That's what the BBB does, but to businesses. And yeah, anybody. So you and I can go onto any business website or go onto the BBB and make a complaint or say something good about or a compliment about a business, and it goes towards their rating. I've never even looked at the BBB website unless I was looking up for a scam. So if I get a call from, so I'm heavily looking for a job right now. I think all of you know that. So when I get some kind of questionable email, that's the first website I go to. I go to the BBB and see if they're a registered company. If they are, I will look. If they're not, or they might not even be a registered company, but people may have left reviews on them. So yeah, they do something. How do they get paid? I have no idea. No idea how they get paid. No idea how. I don't know if it's a government-run agency. I have no idea, but it is legit. It is.
It's called Wrap Your Ride.
Joshua?
Yes.
Has this been done at another place too?
Negative, man.
Different car, but yeah, same type of work.
All right, so again, the total amount that is due is the 946 plus the late fees. And at this point, I've heard all testimony and I've seen all work here done on both ends. And what I am going to do is, at this point, Joshua, I understand that you did go in a place looking for a wrap, not a paint. Well, you got a wrap and you didn't get a paint job. So obviously in that difference, we know that there's going to be a difference in look and appearance as far as paint and a wrap. I've had a wrap done many times on my car. I've had paint jobs done on my car. They're completely different and they come with completely different circumstances and outcomes. Hence is why one is way cheaper than the other. Yes, sir.
Ma'am, it's two different things. The vinyl on the car was wrapped. The calipers weren't supposed to be. That was the path he elected to choose. So that's why when it's corrected with the yellow, that was done the correct way and painted. And that's where the discrepancy came between him and myself.
That's completely false because we have
because I have the mock-up pictures of everything he sent of how everything was supposed to look.
Okay, so I have the invoice right here and it says a wrap on all four in reflective red. So I don't know what your intentions are that you came in, but the invoice that was dated says wrap.
Okay, ma'am.
Okay, so that's what we went with. I mean, that's what the invoice had said. So again, I don't know. That started the confusion right there. That's what it started the whole ball rolling.
Saying, let's go ahead
Okay.
and go through the wrap.
So, all right, I'm gonna make my judgment already at this point. So I read the invoice. The invoice does say it's a wrap. I do know that the Formula Ones did complete the job. So whether it was satisfied or not, I understand that there has been a lot of unsatisfying by the pictures amount. So what I'm gonna do is I'm gonna split the difference. And at this point, no late fees are being charged. We're strictly just for the 946.13, and I am gonna split it in half. So the amount due is $473. It's due to him. Because ultimately, the job was done. Whether it was satisfied or not, it was done.
Could you repeat that amount, ma'am?
Yes, 473.06.
Thank you, ma'am.
Business owner got screwed here. This guy just saved $500 on his car getting wrapped. Don't agree with that. Don't like this. But, the business owner getting another $500, that may have made this job a wash and not just losing money on it. So it may have been worth it at the end. I don't know. I don't run his business. I know nothing about car wrapping except for, you're just putting a giant sticker on your car. Anyways, that's all I got. I'm out. I'm out. And I am sorry to say I'm not going to be in Discord tonight. I'm going to take the night off Discord. I need to get some sleep. So you guys all have a great night. Go hang out on Discord anyways. There's always people there. It's always a fun time. You guys don't need me to have a good time. Promise. I promise. So you guys have a great night. Thank you for hanging out. Thank you for everything. I will see you guys tomorrow. Until next time. Bye.
Joshua gave me all of these pictures, but I want to just double check. He gave me text messages, right? Okay. And then this. I think he gave me everything on the phone. But everybody does have 21 days if you like to appeal the case. But other than that, the judgment's going to stand for 473.06. Okay, thank you
Honor.
guys. Y'all have a
Appreciate
great day.
You as well.
Thank you. All right, that concludes our docket for this morning.